Welcome to the seminar. My name is Melinda. I work here at Merthyr Law doing a lot of the estate litigation with Kieran and Steve. And I'm sure you've heard both me and Kieran and Steve say a lot in this area that superannuation disputes are growing about as fast as the wealth is actually accumulating in that area. And a lot of these disputes are not so much saying, hey, I should get more out of the superannuation in the same way as a family provision application might. They're more disputes around the validity of a nomination that's been put in place by someone during their lifetime. If the nomination is valid, it might go one way, and if it's not, it might go another way. And the question of validity often comes down to the trail of the deed and the variation that has been made throughout the time. So this webinar today that Kieran's going to have for us is what is your exposure in that area if the nomination is overturned. Kieran's our super fund specialist and he's tackled many of these disputes in practice as well. Before I hand over to Kieran, if you have any technical difficulties, I've put in the chat, if you scroll up to the very top, the numbers that you can call and the ID to use to log back in just on a phone call, and you'll be able to hear us. And if you have any questions, please feel free to put them up either in the chat or the Q&A. I'll be monitoring them throughout the session and I'll alert them to Kieran so that we get the answers that you guys want. And be creative, because the best one's going to win a bottle of wine judged by me. So it is going to be a fun session, hopefully. And without any further ado, here's Kieran.
Thanks very much, Mel. So before I get on to the slides, I guess, questions, love them. You know, as I said, if you've got a question, if I'm not making sense with something, it's probably there's going to be more other people in the audience who have that same question. Unlike a face-to-face presentation, I can't gauge the audience response. So, you know, please keep those questions coming and you know, be in the prize to win. So before I kick off the slides, I guess, you know, Mel was saying she's, you know, done a heap of work in the estate dispute area. And what we're finding is more and more with clients, the lion's share of wealth is often tied up in their superannuation. You know, whether that's young people who've got a big insurance payout, or whether that's retirees who, you know, have planned well and have got most of their assets apart from the family home inside that super fund or that self-managed super fund. APRA in December said that the Australian superannuation system had over $2.6 trillion worth of assets in it. You know, that's a huge amount. You know, it's hard to even fathom what that amount is. But of course, when you've got any wealth, you've also got family tied to that wealth. And, you know, the estate litigation, those kind of disputes have, you know, kind of taken over from the personal injuries for the no-win, no-fee lawyers making those kind of claims. And more we're even seeing the no-win, no-fee lawyers going into this super space. And so today I'm going to go through initially talking about some of the recent cases in that space and how technical the courts have been in those cases. I'll be having a look at, you know, what the common grounds that we set aside nominations and some of this death benefit planning inside super are. I'll be having a look at some of those legal cases, you know, that have applied for us lawyers for negligence in, you know, the preparation of wills and that estate planning side, and how they easily transpose to your binding death benefit nomination planning. I'll be having a look, particularly for you guys, you know, what is legal work, what's a legal service, a legal practice, having a look at that, and particularly with a view to the preparation of trust deeds and the ordering of trust deeds and nominations and that side of things. Having a look at a couple of other issues that I guess you might face in practice, you know, that give rise to some negligence risk. And then most importantly at the end, some takeaways of, you know, what can you bring into your practice to help mitigate that risk moving forward, so some real take homes. So a lot to cover, and I'll get things kicking off. All right. So the point today is to scare you, but not necessarily to arm you with some information too. All right. So today's talk I've done before for some television education network events. But today's talk is specifically aimed at those advisors in the self-managed super fund space, particularly financial advisors and accountants. It's an open talk today, so lawyers are welcome too, and we do get a lot of referrals from lawyers, and so there's a few lawyers in attendance in the audience. But I'm particularly focusing on that space of accountants and financial advisors practicing in this area. And look, I feel for you guys. Hey. There's just so much regulation you've got to get your head around for the accountants with all your Corporations Act, all your ASFL compliance, with your FASIA compliance rules. So not only do you have all of this regulation that you've got to comply with, is so many accountants and financial advisors to an extent, your end clients expect you to be a master of all trades, know the voluminous tax rules inside out, know the super rules inside out, know a bit about law, know a bit about the trust deed, know about the pension planning, and they want all of those answers, and sometimes they don't want to pay for those. And so today, part of what I'm trying to get across is, let's stop, slow down, think what the task is at hand, and think what might be involved in that, and having the client appreciate the importance of some of these things that you're doing for them. In my experience, there's a large number of accountants and financial planners that are ordering self-managed super fund deeds through the online portals, and even ordering changes of trustee through those portals. And I know some of those are doing them without even legal review and the deed updates and those types of things. So I'll be having a look at what the risks might be in doing that online process, and accountants and financial advisors going through that process and ordering it through those online kind of portals. Okay, so just to start off, I'm not going to give you the big legal background and case note of every case. What I'm trying to do is paint a picture to you of how technical this death benefit planning area is in self-managed super funds. Now, self-managed super funds, obviously, and every superannuation fund in Australia is a construct of the deed, the trust deed that governs it, and trust law, dating back to the Magna Carta and to the courts of equity in England in the 1200s or way back then. So that law that's developed until then, but more recently having a look at what are these cases in Australia and what do they mean for us in practice. The famous one, one of those first ones for the death benefits disputes was Katz and Grossman, where the daughter was co-trustee with her dad, and then dad died and daughter appointed her husband as trustee and paid all the benefits to herself. Everyone says that that's a case says that your will cannot govern your super. That's not true. That already conceded that. And so the case was actually a fight about whether the change of trustee was effective. Donovan and Donovan was a Queensland case, going back about 10 years ago now. And in that case, Justice Freiberg compared the plight of members of self-managed super funds trying to find their way through the voluminous regulation and legislation and trying to figure out their death benefit planning and where it might fit in all of that. Justice Freiberg compared their members' plight to that of the mythical Uma bird. And I didn't know what that was, so I looked it up. And it's a bird that's got no legs, and it's named after the cry that it makes every time it tries to land. And so that's what he thought of the members, with how complex this super environment is. In that case, the binding nomination had been done by the member, didn't fit the requirements of 6.17A of the Act, hadn't been witnessed, and those types of things. And His Honour in that case found that it wasn't an effective nomination. What's usually the situation with these is second marriages, and so the super fund's shared with the spouse takes over as a trustee of the super fund, and so instead of the members' benefits, those death benefits going to the member's estate and his kids from the first marriage, those super benefits are going to the surviving spouse. That's often the way these things play out. Iapolo and Conti. That was a case in Western Australia that went on appeal. That was a case where, exactly that again, where husband and wife, second marriage, wife died, husband, as the continuing director of the trustee of the super fund, paid the benefits to himself. The court upheld that, and one of the main reasons the court upheld the exercise of that discretion in favour of himself is because he went through the process very well, and he got specialist legal advice to help him out through that process. And, you know, we're looking there wasn't any binding nomination in that case. Munro and Munro, another Queensland case. And in this one, the accountants wrote to Mr. Munro, who was a practicing lawyer in Brisbane, and said, hey, you need a binding nomination. And he said, oh, buddy, I don't want to pay for one of those. And just make it to the trustee of my deceased estate. So they did that. And, you know, he filled it out. But the actual term of the nomination said, you know, an eligible beneficiary was a legal personal representative. The deed said that too. And the super rules, you can only pay death benefits to a death benefit dependent. That's a spouse, a child, someone in a dependency or interdependency relationship, or the legal personal representative of your estate. So in that case, it went off to court whether this nomination was binding or not. And the judge found, well, no, they're two separate legal concepts. The trustee of your deceased estate is not the same as legal personal representative. And for many of us, we go, oh, look, surely he knows what he meant. Surely, you know, they can uphold that. But the courts are taking this technical approach. You know, it's always been a technical construction of trust deeds, and the form of the trust deed is important. If the trust deed says that you've got to rub your tummy and pat your head, well, that's what you've got to do, you know, to comply with those terms. If you don't meet that, it's strict compliance, you know, generally you're ruled out. In that case, in Munro and Munro, one, there was some, you know, looked like there was some backdating of documents by the accountant, which never looks good going on to a Supreme Court judgment. And two, you know, I've got no knowledge whether there was any negligence claim, but in this one, the accountant said, hey, you should have a binding nomination. He gave him one. And, you know, as the accountant making a warranty and a representation that this nomination will work as they say it would. And so is the accountant possibly liable to, you know, the beneficiaries, the kids from the first marriage who missed out? Cantor Management Services and Booth in this case was one where the trust deed said a nomination to be binding, the member has to serve the nomination on the trustee. And so this one went to court as whether the trustee had been given that nomination. In that case, the registered address for the trustee, Cantor Management Services, was the accountant's office. Under the Corporations Act, you can serve a corporation by sending or leaving a note with the registered office. And so the court found the member, by doing that nomination and leaving it with the accountant, had served the company. You know, that makes a lot of sense. The argument there that they were trying to make was that, well, that was on behalf of the member. The member had never transferred the file over to the trustee, and the court just didn't accept that argument. What it did say is that the accountant has a duty to, one, keep that nomination safe, and two, bring it to the attention of the trustee. I'll speak a bit more about that soon. In Re-Narrowman, that was a huge case in, again, Brisbane last year that dealt on so many different issues. But I have an interview on Merthyr Law's YouTube channel with the counsel for that case, Richard Williams, where we discuss all of those issues and the implications of that case. But what I particularly want to highlight today from that case is the trust deed issues. And so in that case, there was an old deed, and it had a raft of different updates, so deed variations, as you get with those older style deeds. When the law changes, they update those deeds. And so, of course, if you want to try to do a binding nomination, you've got to figure out what deed is the applicable deed is the first step. So, you know, they have to do that forensic exercise of which deed which deed is the operating or the governing deed. And the accountant in that case picked up that the 2007 deed variation had a defect in it, as in it wasn't executed strictly in accordance with Section 127 of the Corporations Act. And so the previous deed to that was a 2004 deed. Now, to do these nominations, of course, they wanted a new modern deed by a good law firm that had solid death benefit provisions in it. So they wanted to update that deed before they entered into any death benefit nomination, any replacement one for the attorney to enter into. And so what they said is, hey, we're going to ratify that deed, that 2007 deed, despite that defect in the execution. And otherwise, we're updating the deed to this current deed, to the terms of this 2014 deed. And the court found there, well, no, if a deed was defective, it's defective. You can't rewrite history and pretend it was executed correctly. So, the lesson from that case is deeds of ratification for trusts generally don't work. You can rectify it perhaps from the date of the new deed, but potentially, all of that period until between 2004 and 2014, the trustee was operating under that 2004 deed rather than the 2007 deed. Thankfully, in that case, though, the variation was drafted widely enough that it worked under that 2004 deed, so it still brought those terms up to the the modern deed that they wanted. So the deed was updated before they did that nomination, so there was some saving grace there. Another issue in that case was about the lion's share, I think about 3 or 4 million of the 5 million inside the fund, or 3 million of the 4 million in the fund, was in what was called a complying reversionary pension. What that means is automatically with a reversionary pension, those members' death benefits, they automatically go on the member's death, they automatically are vested in the survivor. So it becomes a pension where the survivor becomes a member of that pension. Typically it's the surviving spouse, that reversionary beneficiary. Now, despite having all manner of other documents, they could never find the pension commencement minutes. So there was no evidence of the terms of this pension or how it was ever created. Of course, all the financials reflected this pension. And what was a saving grace in this case was that the auditor, the actuary does calculations for these old style complying kind of pensions, where if it's reversionary, it's a different sum that gets paid out and a different calculation than if it was non-reversionary. So despite there being no evidence of that pension commencing in that document, the judge in that case, Justice Bowskill, was still prepared to uphold that that pension did exist. In my experience, a lot of pensions that were commenced before 2007, they're reflected in the accounts and in the financials, but often we ask for them and we can't find any pension commencement minutes. So that's a real sleeper, because a lot of those more what were called allocated pensions back then, now account-based pensions, we can't fall back on those actuary calculations. The whole pension can get paid out each year. So without those pension commencement minutes, we could be in trouble there. Most recent case, Victorian one, re Marsala, and that was another case where mum was in her second marriage, daughter from first marriage was co-trustee, mum died, daughter appointed a sister and paid all the super benefits to herself. It was an old style deed, so from what I gather, there wasn't a clause in there permitting a conflict of interest. And the judge overturned the exercise of the daughter's discretion as trustee in that case and made a comment and said that she really should have got specialist advice. It was an important area, and, she should have taken her trustee duties more seriously. And, she came unstuck because she didn't follow the right process and really entertain her stepdad's and, the estate's claims upon that super and didn't approach it in the right way. So that discretion was overturned as a breach of trust in that case. Thankfully, in that case, the accountant looked pretty good at the end of it. The accountant had recommended that she gets a specialist advice, and the law firm that was acting for the trustee in that case didn't look really good, because they've got a judgment saying your advice was improper, you went about it the wrong way, and you weren't a specialist firm. So I guess from that and Iapolo and Conti, there's a bit of it's kind of clear from these cases that the courts consider that trustees in these situations, especially if there's any touch of conflict or there's these complicated issues, should be getting that specialist advice. So what kind of grounds can nominations be challenged for in these pensions? And I'll just quickly go through these. Like Mel said before, you've got these lawyers, you've got an unhappy stepchild or child from a first relationship, and they come up with whatever reason that they think they're entitled to the money. So they go to a lawyer to try to find some chinks in the chain there. And typically, the nomination itself fails, it wasn't witnessed properly, the terms of the deed weren't complied with, i.e. that the deed required it to be approved by the trustee. There's no evidence of that. Non-compliance with the payment standards. For example, you pay it to a brother and you're not allowed to pay it to the deceased brother. You're only allowed to pay it to one of those death benefit dependents I talked about. There's a tax ruling, TR 2013/5, which talks about when a pension commences and ceases. One example when a pension is deemed to cease is when the minimum pension payment hasn't been made, or if it never properly commenced. So you can imagine lawyers will be going through, and forensic accountants per se might be going through all of the payments from the super fund and trying to come up with an argument that this pension ceased at a certain time, which has tax consequences for the fund. But the point there is it might not be a reversionary pension, up to the trustee's discretion, and then that can go to a different beneficiary. Like I've mentioned, is what's happening now is, especially those older deeds, is you go through every deed variation, and it might be 10 of them, and you're likely to find some problems in them. I know with when you deal with those older super funds and you'd be dealing with limited recourse borrowing arrangements, often the banks would get you to do all manner of deed rectifications, and even they'd do ratifications, which are questionable now after renarrowment. But it's especially those older deeds, it's not hard for us to find some kind of problem we can hang our hat on. And the effect there is there's an old deed which didn't allow for binding death benefit nominations. It hasn't properly been updated to the new terms. It's not valid. There's been a change of trustee which was ineffective, and so therefore, the trustee's actions are all invalid because they're not the trustee. Another one is maybe a binding death benefit nomination has been done under an old variation that's updated. Does that update inadvertently invalidate that old binding death benefit nomination? Other grounds for challenging for New South Wales assets or domiciled super funds, notional estates, there can be claims on that. And a big one too is, especially with the more elderly members, is whether they were incapacitated and so they didn't have capacity to make that nomination at the time, or were suffering from undue influence from another person. It can be set aside on those grounds. And I guess you use a good estate planning lawyer is one benefit from that is, they're trained to do these capacity tests, and they take pretty good file notes that they keep. So, that's one good thing of getting some professional help. All right, now got that stuff out of the way, the legalese, and so now I'll be talking about some specific case studies for you to have a look at. So under this one, we've got Betty and Bill, one of these situations where they're a second marriage. Betty's got children from her first marriage, and so she, in her self-managed super fund where she's co-trustee with Bill, she does a binding death benefit nomination to her estate. Betty dies. Now, Bill is a bit of a rogue. He goes and he, as the continuing trustee, sacks the fund's accountant, and he pays all those death benefits to himself using the trustee's discretion. He never tells the estate about the existence of this binding death benefit nomination, and they don't have it in their hot little hands. And, you know, as practitioners in will disputes and death benefit disputes, you know, these people exist. This kind of stuff happens. And, you know, what's the consequence here, I guess? What I'm specifically looking at is, what is the accountant's duty in this case to the executor of the estate, or the beneficiary of that binding death benefit nomination, you know, the children from that previous marriage, ultimately. So, 30 years ago in Brisbane, ended up going all the way to the High Court, a case of Hawkins and Clayton. In that case, a law firm had prepared a will for a testator. The testator passed away. The law firm knew about that, but they didn't do anything, didn't tell the executor about the existence of this will till some 6 years down the track, at which time the main asset of the estate, a house, had gone into disrepair, and so the estate suffered economic loss. And so the court found in that case, well, the law firm had a duty, well, to the client and, you know, well, to the executor, to inform them of the existence of this will. In that case, an executor really stands in the shoes of the deceased person, and so that makes a lot of sense. You know, what's the point of doing a will if nobody knows about it? Now, it's not hard to see that this could pretty easily apply to a binding death benefit nomination. And in Cantor Management Services and Booth, the court found that the accountant had a duty to bring it to the attention of the trustee. But the binding nomination is really done for the member, isn't it? It's done as an exercise to ensure the member's death benefits are dealt with in a certain manner. And so really, if the accountant helped prepare this nomination, well, the accountant, to some extent, has got a duty to, to that member, at the very least. And so therefore, it's not hard to make an argument on the basis of Hawkins and Clayton that the accountant's got a duty to at least tell the member's executor about the existence of this nomination. So, you know, something to think about, and, you know, wonder if you want to have policies with respect to that. Let's say if the nomination wasn't to the estate, was to, you know, the children directly, I don't think it's that hard for the next court decision to say that, you know, the accountant has got, or whoever prepared that nomination, has got a duty to make sure that the beneficiary of that nomination is made aware of it on the member's death. Another Brisbane case, Hill and Van Earp, went all the way to the High Court again. In this case, the testator, she had a house, and so she left that house half to her son and half to her dear friend, Mrs. Van Earp. Unfortunately, when the solicitor went to execute and witness the will, the solicitor had Mrs. Van Earp's husband as a witness to the will. As the Succession Act was at the time in Queensland, that where a witness, so where a beneficiary or their spouse or a relative is a witness to the will, the gift to that beneficiary fails. They don't have that strict compliance anymore under the Succession Act, but at the time they did. So what was the consequence there? The consequence was that Mrs. Van Earp missed out on her expected inheritance under the will because the solicitor stuffed up that execution meeting and didn't mention that Mrs. Van Earp's husband shouldn't have been a witness. But in this case, well, the legal firm had a retainer with the testator. And when the testator died, well, the estate, you know, takes over, I guess, and the estate wasn't diminished. It's still got a house. It's still worth the same value. It's just that all of that house is going to the son rather than going to the son rather than going to Mrs. Van Earp. And in that case, well, it said, look, the Mrs. Van Earp's interest coincided with that of the testator. So, you know, it was reasonable to expect that if she was engaged, the law firm was engaged to prepare a will to give half a house to Mrs. Van Earp, that's what should have happened. And so the solicitor was found liable in negligence to Mrs. Van Earp in that instance. And so that's where negligence arises, you know, that's that duty that as a professional advisor, what you do could affect third parties, and even though that third party, you don't have a contract with them, you can be liable in negligence to them. With these negligence claims, when are you liable until? What about this statute of limitations? And so the statute of limitations says the claim has to be brought within 6 years of the cause of action arising or reasonably coming to the attention of the affected party. So typically that's on death. What that means is nominations that have been prepared some 10 years ago, you can still be liable for them in 10 years' time, 20 years' time. Nominations you're preparing now could be a real sleeper, and there could be liability down the track if they're not binding, in fact, and a beneficiary misses out. Then there was a more recent case, a Tasmanian one, that also went to the High Court. And in that case, the solicitor met with the testator and failed to advise the testator, did the will as instructed, but failed to advise the testator that some family members had a potential family provision claim against his estate. And in the first instances, the solicitor was found liable for the beneficiary who missed out because there was a family provision claim against the estate. But the High Court said, well, look, in this instance, we can't know what the testator would have done because the testator might not have wanted to spend the money to rearrange their affairs to possibly avoid this family provision claim. We just don't know. And so in that instance, they said, well, the beneficiary who didn't get as much because there was this family provision claim, their interests didn't coincide necessarily with those of the testator who the law firm had the retainer with. And so therefore they didn't find that legal firm liable in negligence to the disaffected beneficiary. No questions yet? Anyone pop in when you want? All right. Now, looking at this one is all right. We've just got a question from Marina. Yeah. Sorry, Matt.
No, I was just going to point that one out to you. Go ahead.
How often are memorandums of wishes used to explain the reasons for nominations? Yeah, good question, Marina. Look, they're used quite often, to give a bit of a backstory of this is what I planned, and especially they're used for, the longer term of, this is how I'd like a trust to be administered. And as far as your family provision claims go, though, they're not really worth much. They're only as good as really noting that, well, the testator didn't forget about that beneficiary, but it doesn't avoid a family provision claim. As far as whether a nomination is binding or not, the wishes don't matter. So you have these non-binding nominations. You often see this big super funds allow for them. Often I don't really see the point because 9 times out of 10, the big super funds ignore them and they're not bound by that non-binding nomination. It's just of interest to them. So as much as they're good for telling family members a bit of a story and where your head was at, legally they're not really effective. Thanks, Marina. Good question. All right. Moving on. So this is a case where here we got Colin, was sole member of his self-managed super fund. He was too tight to buy a company to be the trustee of that self-managed super fund. So to comply with the super rules, he had his daughter Sonia as a co-trustee with him. Colin hooked up with Jennifer as a de facto. And what's the first thing you do when you find a new person to move in with? Of course, you call your accountant and say, hey, can you get Jennifer onto my self-managed super fund? And the accountant says, yeah, no worries at all. Prepare the minutes and the resignations. And so what the accountant prepared was a resignation of Sonia and also minutes, minuting the change of trustee from Sonia to Jennifer. That was all done in 2015. In January 2017, Colin made a binding death benefit nomination under the deed to Jennifer. Then, a change of trustee in 2017, it was really trying to confirm this 2015 document. But it came out, well, it was dated in 2015. So again, it didn't look really good being on a court judgment, you know, where it appears that the accountant has backdated this document. And look, you know, it looks pretty clear. In this minutes, everyone signed it. Colin signed it, Sonia signed it, Jennifer signed it. Everyone signed these minutes of this trustee change. But that doesn't stop Sonia from feeling, hey, it's not fair that Jennifer, I've never really liked Jennifer, that she's getting all my inheritance and my super. So she went off to the lawyer, and the lawyer looked through, and they came up with an argument to say, well, strictly speaking, under the terms of the deed, the trustee resignation was required to be accepted by the trustee. There was no evidence that the resignation was accepted. It's got to be given to the trustee immediately, any notice of removal and appointment. There wasn't evidence of that, and there wasn't evidence that it was in writing. And the judge said, yeah, technically speaking, under the deed in this case, you know, some of those are valid. But in this instance, because there was this document that was signed by all parties, you know, that evidences that it was in writing, and it evidences that notice was given to the trustee. So lucky in that case, I guess, that Colin's his wishes with respect to his death benefits were carried out. But it could easily have gone the other way too. And it just shows you, you know, how prepared people are to go and fight these cases. And how technical, I guess, they're getting in these cases.
Kieran, can I ask you, how many times do you see a deed that says something like the trustee must accept, or the trustee has to do such and such particular step in order for a nomination to be binding? Yeah,
good question. And so, for example, there's one common deed provider that's used in that's based in Queensland, but used throughout the country, used by a lot of accountants and financial planners. And in that one, you've got the binding death benefit nomination in Schedule 2. It looks pretty straightforward. You know, the nomination witnessed by 2 people. Then, you know, I was asked to do a binding nomination for one of these deeds once, and I had to give a notice by the trustee to the members where the trustee had to disclose everything possibly relevant that the member might need to make their decision with respect to a binding death benefit nomination. The member had to write back to the trustee, giving the trustee directions. There had to be a meeting of the trustees to accept this. Then the nomination had to be issued, and it had to be served on the trustee again. I might not have it exactly right, but along those lines. And I did that once. And I was quite worried that, you know, how do I know what's relevant for the member making this decision? And, you know, perhaps that could be changed. Now, I won't do any nominations under that deed. I'll make sure I either update the deed to our terms, so we've got simpler provisions for nominations, or, you know, replace those death benefit provisions with our own. With that deed that in question, now I guess on that Schedule 2 with the binding nomination, they got a warning saying, hey, you've got to read the provisions of the deed. But, you know, that's a really good point, Mel, that just because you've got a nomination attached to a deed, you know, you've still got to read the deed itself, and you've got to comply with those provisions. You know, we do a heap of change of trustees here, and, you know, there's some real funny old deeds around that, you know, make you give 30 days notice before you can do it, you know, get another party involved in giving that notice. And so, you know, it makes me wonder how there can be these changes of trustee deeds that are done online where they don't consider all of these kind of provisions. Yeah, so I guess, Mel, yeah, good point. You can't be satisfied just filling out a document. You've got to read the deed and understand the deed. And so, sorry, this case for that change of trustee was Perry and Nicholson in Queensland. Another case that didn't go the trustee's way was this case of this case here, there was the same trustee. Photography Management Services was trustee of the super fund as trustee for the business family trust. The sole member of that fund died, and the question was, after he died, there was a change of trustee that was done, changing the trustee from this entity to Moss Super. And the question there, the implications for that was, if this PMS, Photography Management Services, had remained the trustee, the lawyer was a co-director of that, who was the executor of Mr. Haynes' estate. Consequence of that was, the death benefits were more likely to go to the estate, and again, those kids from the first marriage, rather than to Miss Moss. In this case, there was a resignation that was prepared for Photography Management Services that was effective. Minutes of meeting of members to remove and appoint Photography Management Services and consent of Moss Super. The court found that wasn't effective because the deed said it was Photography Management Services, not the members, as the principal employer or the founder, that had to remove that trustee. Look, just in this case, I guess the point I'm trying to make here is you can have binding death benefit nominations which have a bad outcome. It might be everything to the spouse, and it might have said it's as a lump sum. And you don't want that money being removed from super for Barry because he can't put it back in. It might be that there's children who are, only infants, 2 or 3, and you wanted some ability to do some child pensions inside that super. You got a binding nomination to the spouse. Well, then, you're stuck with that. So a good option is to have a deed that allows you to really, for that beneficiary of that nomination to renounce their interest and send it back to that trustee's discretion. So just going through, I know I'm running out of time a little bit, so just running through, I guess, looking at what's involved when you're updating a deed. Is it just filling out some variables on an online form? So what have you got to do? Well, we've already said, really, to find out what deed you're changing, you've got to review the validity of all prior deeds. You've got to identify what's the applicable deed. Check the variation power and then draft the deed and make sure you comply with that variation power. Really, if you're doing a deed upgrade, well, you should be ensuring the client's aware of the terms of that deed and, whether it's suitable for their purposes or not. Draft that deed and making sure it complies with all of those deed requirements. Then there's strict requirements for whether a deed's executed properly or not. We saw in Re Narraman what the consequences are if it's not. And so, checking that it was executed in accordance with the requirements of a deed, wasn't witnessed by a party to the deed, was executed in accordance with 127, all of those kind of things. And, for changes of trustee and that kind of thing, stamping that. And so there's a lot involved there. And I guess if you're doing these online updates, is that, have you done all of these aspects? And if you haven't, have you clearly said to the client that you haven't done any of these things and it's at the client's risk because, you're not a lawyer? What is your retainer, I guess? Having a look at a lot of these things, I guess a lot of this involves not just filling out a form, does it? When you're updating an SMSF, it involves really analysis of what the deed is. For those changes of trustee, making sure those clauses are appropriately complied with. So having a look at, well, hey, is being involved in updating deeds, changing trustees, doing binding death benefit nominations, are they legal advice? And so there's different acts around the country, but the Legal Profession Act prohibits people who aren't legal practitioners, that's, practicing lawyers with their insurance, prohibits them from providing legal services or a legal practice. The main purpose of those provisions is to protect the public interest, to make sure there's a good delivery of the law, and also to protect consumers, to make sure that, they're not getting ripped off and at least, well, they've got some insurance when they're being provided with that legal advice. The consequence of providing, a legal practice, a legal service without being a legal practitioner is up to 300 penalty units. So that's about $50,000 in today's terms, or 2 years imprisonment. In Queensland, there's no definition of what a legal service, a legal practice is. but there is some exceptions. So they say, well, it's okay for real estate agents to prepare REIQ contracts and even put in some special conditions that have been approved by lawyers and fill out the relevant disclosure forms. That's not going to be legal advice. Specific exception. There's a specific exception for trustee companies drafting wills. So those professional, trustee companies. In Victoria, and WA, and I think South Australia, they've got even more specifications there. And in Victoria, that's drawing, filling up, or preparing any instrument, creating or regulating rights between parties. And some other ones, talk about filling out those deeds. So, although it's not mentioned in our Act, there is the case for an argument that even ordering an online update to a deed could be legal advice. I personally think that, if you've got an appropriate retainer with the client and they've, want to update to whatever, provider you're using, they've got an information memorandum about what their deed contains, largely, and you put it on the client for taking that risk and say get legal advice if you want to check it. I don't think you're giving any legal advice there. All you're doing is filling out a form. If, however, it's a deed variation and you've got to have some input about whether the trustee is allowed to vary the deed, or if it's a change of trustee where you've got to have some input about what the change of trustee provisions are, who's entitled to change the trustee, that's legal advice. And it's not covered by any Commonwealth exclusion for your tax agency licence or otherwise. So yes, there's the risk of the Legal Services Commissioner prosecuting you for a commission of an offence. But the real risk, I guess, is one, you're not entitled, your fee's not recoverable. But more importantly too, is for accountants and financial planners, check your professional indemnity cover, but it's unlikely that your professional indemnity cover will cover you for providing legal services. And so, your firm could be liable for doing this kind of stuff. And ultimately, the consequence of that is a beneficiary missing out on hundreds of thousands of dollars, even millions of death benefits. That's a big risk to have hanging over your head. So for your online deed providers, a lot of their terms, if you have a look at them, they say, look, we're not a legal company. We're not a law firm. This is a pro forma deed. If you want to get legal advice as to whether it's suitable for you or is effective, you should get legal advice. That's not us. You should get your own legal advice with respect to it. So, they're contracting out on their retainers of their liability. Already talked about trustee changes and variations and how that's likely to be a legal service. Binding nominations. So, family lawyers, when they talk about the financial agreements, some people refer to them as prenups. The Family Law Act calls them financial agreements. It doesn't call them binding financial agreements. The family lawyers won't call them binding financial agreements because that's ultimately for the court to decide whether they're binding or not. However, as an industry-wide thing, we're calling these death benefit nominations BDBNs, or binding death benefit nominations. Merely by saying that that nomination is binding, that's legal advice. You're saying that it's effective under the terms of the deed and the super laws. Even if you're accepting a nomination and calling it a binding nomination, is that providing legal advice? Are you covered for that? It's a pretty complicated area. That case there was a case where a Western Australian practitioner got in trouble, got prosecuted under the rules for selling a deed, a super deed on their website. Ended up getting out of it on a technicality because it didn't cover corporations at the time. But like I said, the big one here is playing in this space is, that PI insurance isn't likely to cover you. If anything from today, what I'm saying is stuff that's been done already, nominations that you've helped prepare already, nominations that even the clients have done and been given to you, there's a real risk that there's a dormant sleeper negligence claim, just waiting on the sidelines, and you might not be insured for it.
And Kieran,
Yeah, Mel, I just...
That's okay. The limitation time generally starts possibly on death. Could that sleeper issue come up during someone's retirement?
What do you mean there?
So if you've retired from your firm, from your accounting firm or whatever a few years ago, and the person dies a few years down the track after your retirement, and the negligence action pops up a little way after that, you're not even part of the practice anymore, but you were the one that did the work originally.
Yeah, potentially. You got potential liability for the one who committed the negligent act. That's a lot harder to get up. But also, if you did a business sale rather than a share sale, I guess is the liability stays with whoever provided that service or whatever your entity was there. I'll talk soon about what action you might be able to take to try to get off risk for some of these nominations that might have been done in the past. How am I doing for time? Got about 10 minutes left. So look, I've been obviously honing in the area that I specialise in on potential risk for accountants and financial advisors, and even lawyers who aren't specialists in this area, and even lawyers who are, of negligence claims in the death benefit space. At least lawyers are insured if there is a death benefit claim. But just want to briefly raise other risks in practice at the moment. And third-party fraud's obviously a big one, but we're really seeing this cybersecurity fraud. And I'm hearing of people these are financial advisors that I know quite well. They've had their clients' emails have been infiltrated, and they even speak like the client, and they request some pension payments and up it a bit. And you have someone on the switch, and they just action those requests and don't think about it too much. And there's potential liability for paying it out to the Nigerian scammer. Cybersecurity and training your staff up on that is just so important, and our insurer is really drumming that into us lawyers, because we're talking hundreds of thousands of dollars of diverted payments that have occurred. It's not just your spookers and your swindlers with that third party fraud. It's largely that cyber fraud now. In the last year or two, these Camembert and Ryan Wealth Holdings cases, have scared the bejesus out of self-managed super fund auditors. And in those cases, the auditor was auditing the self-managed super fund, and in Camembert, the auditor was found liable because there was an entry in the financials of the fund that said cash, but it wasn't really cash, it was an unsecured loan. And so the court found that the auditor should have picked up on that. And so even though the client said, hey, I trusted the accounting firm, that was, or, the advisor that was spending all of my money, I probably wouldn't have even changed it if I had seen it was an unsecured loan. But on appeal, the auditor was still 90% liable in negligence there. In Ryan Wealth Holdings, again, it was a loan situation, and the loans didn't have a lot of security behind them, and the court found that the auditor should have put qualifications on the value of those loans, because obviously just because a loan on the paper might be worth millions of dollars, that's got to be discounted if it doesn't have that assets, or it's not likely to be repaid that amount. And so the auditor was liable, I think, about 1.6 million before interest and costs in that case. So now auditors are being really, really conscious of putting relevant disclaimers and qualifications in their audits, and they're asking a lot more questions and of those investments, those obscure investments more in unlisted unit trusts and loans, and those kind of ones that are a bit harder to value. What I'm seeing a lot of in practice is administrative penalties. So these were, it's about 5 years on now. These were brought in, 2014. And they were sold on the basis that it just makes it easier for the commissioner as a regulator to impose penalties rather than going to the federal court. And the thing is in the federal court cases is, let's say for these ones where, there was early access to super and there was illegal loans out of the super fund to the members. in those cases, the maximum penalty back 10 years ago for those civil penalties provisions was $200,000, whereas the maximum penalty for the ATO is $12,000. Well, what is it, about $13,000 this year? But what we're seeing is, well, then in those cases from the federal court, even though there was multiple occasions of them ripping the money out over a series of years, the court said, oh, well, it's only really one course of conduct and we're only imposing one penalty, and out of a maximum of $200,000, the average was around $20,000 or so that they're imposing. Whereas the commissioner, when they do their initial pre-audit letter for these administrative penalties, they're imposing penalties for each occasion under multiple offences and coming up with a figure of millions, well over $1 million for these administrative penalty provisions. So people think, it's a $13,000 penalty, it's not a big risk, but, the commissioner's taking a different approach and really going for the jugular under some of these. You can hopefully get those remitted down and get those penalties a lot less, but, you need to be careful there. Point I'm trying to make to, I guess, accountants is when people get pinged for penalties from the ATO, they're personally liable for that. You know what people are like, they might say, well, hey, my accountant didn't tell me about this, it was their fault, they didn't pick up on it. They like to blame someone else and like to get the accountant liable for the penalty. So, a bit of a risk there. I go to the SMSF meetings, and SMSF is open to all self-managed super funds, and if they're a member of SMSF, which isn't, a particular fee, and I'm not sure what the fee is, it's not a particularly large fee, and that covers at least those first round of those administrative penalties, which is a bit of a benefit. I've already talked about challenging that trustee's discretion and re-Marcella and the importance of getting, I guess, that specialist advice. Look, on another note, I guess, I know a lot of financial advisors and accountants and, do a lot in the financial services space. And Merthyr Law has, had a fair bit of experience over the years in, the compliance work, in AFSL applications, in, your client compliance and your AUSTRAC compliance and, your corporations advices, all of that kind of, real technical stuff that's pretty hard to get your head around. There's a real movement on, for financial advisors to become independent, get their own financial services licenses, those kind of things. All of this compliance in this post-Hayne world is pretty important. That's an area that Merthyr Law is interested in, getting more into. So, if reach out if you've got any kind of queries in that kind of area. All right, now for, I guess, the take-homes, the important bit. What can you do to, I guess, implementing your practice moving forward to make sure you're not one of these horror stories that we talk about? And, being the lawyers, we're always considering whenever we've got a file, hey, how do you get off risk? You've got a lease matter, getting off risk, closing the file down, limiting your retainer. I'm always looking at it like that way. I'm asking, you guys, financial advisors, accountants, think like lawyers like this and get yourself off risk. First of all, if you're ordering online deeds, look, that's fine, but just familiarise yourself what you're responsible for and what your provider's responsible for. Does your provider's insurance cover any problem with the deed? What kind of warranties do they make with respect to it? If they're doing a change of trustee, are they recommending that you get your own legal advice with respect to it? You've got to know what you're starting with, I guess. Now, it's always your retainers. What are you doing? What are you not doing? Now, for example, we do some deed updates, some more generic deed updates, on a wholesale price for some accountants and financial advisors. But if we're doing that cheap price, we're not looking at 15 deeds and doing an advice on, whether a proper execution and, whether they've been validly changed. If you want that, that's more of a golden service. What we do though, is we say, we're updating this deed in accordance with the terms of this deed and, aren't advising otherwise. So getting yourself kind of off that risk, putting the risk on if you're doing these online deeds, that if they want to ensure that it's all compliant, they should get their own specialist legal advice with respect to it. Put those qualifications in there. You know, what you are doing, what you aren't doing, like the auditors are doing with their audits of self-managed super funds now. Generally, look, avoid recommending or preparing death benefit nominations. You know, for accountants, possibly that's breaching over into the financial advice space. But particularly, it used to be the case that, as a matter of course, you know, some super fund administrators with the financials would send out a pro forma binding death benefit nomination and say you should have one. My philosophy is it's not that simple. You know, it's got to be done as part of a holistic estate plan. For a self-managed super fund, for a nuclear family, perhaps no nomination's better than having a binding nomination. If you are involved in helping a client fill out whatever form is on the back of that super deed, again, make sure you qualify it, that you're not saying it's binding, you're not saying it's complying with the terms of the deed and is otherwise enforceable. If they want that assurance, they should get that legal advice. I know it's an industry thing, but stop calling them binding. As soon as you're calling this nomination binding, that by its nature, that very word is legal advice. So try to steer clear of it, or caveat right up. If you do get a nomination from a client, you know, let's say they've prepared it themselves or they've done it in accordance with the deed, you know, have your systems and procedures in place. So there's a pro forma letter that you send out and even get them to sign off on to say, hey, we've received your death benefit nomination, thank you. By the way, we're not lawyers, you know, we make no warranty that it's in fact binding or will do what it says it will do. If you want to get that comfort, you know, we suggest you see a specialist lawyer. What about, and Mel, you were alluding to this before, what about nominations you've already done, you know, where you were sending out the nominations with the financials and, you know, people were just signing them and you weren't really taking a lot of care as to, you know, the technicalities of whether the terms of the deed were complied with, and you're worried that your PI insurance might not cover you for those. Well, better late than never, isn't it? The beauty is that most of your clients are still alive and still have capacity. So whilst they're still alive and have capacity, if you send them a note saying, hey, you know that nomination we did, just letting you know, we're not lawyers, we hope it's binding, but if you want, you know, assurance that it is binding, you should see a specialist lawyer to advise on that. Then the courts are really going to look at that and say, well, hey, you got this notice from the accountant, and you didn't do anything about it. That's on you, the client, more so than the accountant. You know, they could have changed it up, but they didn't. So, you know, still that kind of worthwhile exercise. A lot of accountants have said, well, what about when you get the ethical letters and, you know, you're sending over all of the information in your file? That's also a perfect time to say, hey, you know, any of these nominations that we've, you know, that we've helped prepare or we've received, just you need legal advice to see if they're binding or not. If you don't get that legal advice, that's on your own risk. We're making no warranty, you know, as to whether it's binding or not. I'm sure they might still make a claim. Hey, you paid a retainer, and the retainer was to give us a binding nomination, but you know, for the sake of, you know, whatever they paid you, which probably wasn't a whole lot for that, well, you know, they could have rectified it and that's on them. So, you know, you're in a much better position, and, you know, they're going to be in a weaker position to make any negligence claim, their disaffected beneficiary. As I've said a lot, look, this stuff is so technical and so involved and complicated. You know, you got to figure out trust law, you got to figure out the super law, you got to you know, get into the technicalities of the deed and what constitutes a deed. You can't do everything. You know, use specialist lawyers for this super stuff. You know, there is some old school lawyers, you know, that say they do estate planning but don't do superannuation planning. Well, you know, to be fair, your supers, a lot of your clients main assets now, that's not acceptable. You know, you need to have someone operating in that space that knows about these super deeds and gets it right and helps avoid these pitfalls. One more trick, I guess, before I go, is if you do have a lawyer doing a deed update, a change of trustee, any kind of these deeds, you're still arranging, you know, the execution on that. That's being sent to the accountant. You're arranging the execution. That's a real problem, is if, you know, what we're seeing all the time is these deeds, when we come to fight over them, haven't been executed properly. We can't find the signed version. So it's as if they don't exist. So if you want to get off risk, a good trick there is you send the signed versions to the lawyers and get them to confirm execution, get them to confirm that's been executed properly. That's your classic kind of off risk, is now you've had a lawyer confirming execution, they've taken on the assumption of risk for that, and you've got an off risk yourself. If you're arranging the signing of documents and, you know, they're executed incorrectly, that's your fault. You know, that's not the deed provider's fault. You know, they don't even know about this incorrect execution. And, you know, so you're on risk there for that potential liability, which could be pretty significant. And look, you know, ASIC came out, a year or so ago with a press release where they said, we're a bit worried because there's a bunch of accountants and financial advisors who are witnessing nominations where they're not even in the room with people, who are backdating nominations, who are, you know, backdating documents. I bet that no one in the room, you know, no one in this webinar would be doing that, because you guys are all taking the time to make sure, you know, you're properly educated and you care about, you know, keeping up with the rules. But it's a really bad name for the industry, and, you know, doesn't help with your anti-regulation stance if, you know, that kind of activity is going on. Doesn't look good if, you know, that ever ends up in a judgment. So always, anything that you do, I guess, is don't be dodgy and consider that it could end up before the courts. So I hope, you know, there's been a lot of information to get through. It's been a bit kind of technical. I hope that, at least with some of you today, some of these tips that I've given you can help make sure that your clients' files don't become these wealth transfer files. The wealth being transferred from your client and how they intended it to the lawyers. I hope, you know, we can help do a better job of estate planning generally, so we don't end up in those court cases, or, you know, more likely in those mediations and those disputes. As far as following us, we put out a whole bunch of material on YouTube and LinkedIn, you know, personal and public profile for Facebook, and, you know, the firm's Facebook. So there's a lot of information there. You can watch that at your leisure, or, you know, subscribe to that, you know, join that community. And sorry, I ran a little bit over time, and just wondering if there's been any questions, or if who wins this bottle of wine?
Kieran, we've got another one here from an anonymous attendee. Do you think that accountants preparing documents to change the trustee is legal advice?
Yes. Because they're reviewing the deed and, you know, saying that it's complied with the terms of the deed. You know, I think it's pretty clear where there's a specific exception in the Legal Profession Act for a real estate agent filling out an REIQ contract. A deed of change of trustee is a fair bit more involved than that.
I'm back. And we had another comment, I guess, from Victoria, who brought up a Western Australian case that came up a little while, not that long ago actually, that was more about an administrator of an intestate estate essentially asking the court to allow her to resign so that she could make a claim on the superannuation. But it really just brings home that super fund was worth about $500,000 and the estate was worth about 100. Super is really starting to be the biggest part of estate disputes these days.
Yeah, and it's really technical.
Yeah.
I'm sorry, was there a question with that one, Mark?
No, that was more just a comment, that case, yep. I think that's all the questions we've had pop up during, but if anyone else wants to load one up in the chat or in the Q&A while we're still here, and feel free. But I think maybe Maria's question with the memorandum of wishes.
Marina?
Yep.
All right, Marina, if you can let us know what your choice of wine is, whether it's champagne or Pinot or Cab Sav, I think we've got. We'll organise that to come to you.
Good question.
But we can contact you privately about that, Marina. Hey, look, everyone who's still around, thank you so much for joining us on this webinar. Always love, chatting with you and, being able to help out. And how we operate is you got any questions, for these 5-minute chats with the professional advisors, we don't charge anything, and, we might end up with a job one day, but, love talking with all of you guys, and, I'm a super geek and, like exploring the different scenarios and options, so hit us up.